Hi, everyone. In this lesson, we'll be talking about sexual orientation and gender identity in the workplace. We'll start off with some vocabulary to try to catch everybody up. I have to preface this with the fact that when I was growing up, and I'm in my mid 40s now, sex and gender were interchangeable terms. They meant the same thing, at least where I was growing up. The people around me always used the terms as though they meant the same thing. And recently, we've started to use the terms differently so that they mean different things. So the vocabulary section here is just sort of catch up with the way the terms are being used today, at least in 2024 when I'm recording this. And then over time, things will change. This is the most rapidly developing area of employment law that there is. So I'll give you what's current. And then over time, things will change, probably still pretty rapidly, and then I'll have to just continue to make updates. So with that, vocabulary. Biological sex means it is assigned at birth. Typically, you're either born a male or a female, but not everybody. Some people are born in sort of this in-between classification here that we call intersex, where it's not so clear. Some people can have both sets of genitalia. And at that point, traditionally what happened was parents and doctors made a decision to either make the baby be conforming to either a male or a female. And then people usually just didn't talk about this all that much, but it's becoming more of the conversation now. Now, again, it's very few that this happens to, but it's real, and the people are out there living among us, so we try to treat people with respect. Sexual orientation. This describes to whom one is attracted for personal, intimate relationships. So there's a lot of these. Some examples are the traditional heterosexual, the still pretty common homosexual, and then we get into bisexuality, asexuality, pansexuality, and then the list goes on as people are discovering or inventing or experimenting with different forms of their own sexuality. So that's what sexual orientation means. Gender identity is a person's sense of their own gender. Now, most of the time, this correlates with the sex that you were assigned at birth, but not always. Some people have this nagging persistent feeling that they should be a man or a woman, even though that doesn't correlate with their genitalia. Gender expression describes how one expresses their gender outwardly, usually in the way that they dress, the hairstyles they wear, the way that they behave, the way that they use their voice are all parts of a person's gender expression. This expression may or may not conform to what the stereotypical masculine or feminine expression would be. Transgender is a term that identifies a person who expresses a gender that is different from the biological sex they were assigned at birth. Transgender people may or may not choose to undergo sex reassignment surgery. And being transgender does not necessarily imply any specific sexual orientation. So a person can be transgender and choose what their gender, or choose what their sexual orientation will be, choose what their gender expression will be. So that's the current state of how everything is being described in popular culture. And like I said, over time, things can change, as they have dramatically changed in the last few years. Recent big developments in this particular area of employment law. In 2020, the Supreme Court of the United States ruled that gay and transgender employees are covered under Title VII, making it illegal to discriminate against people because they are homosexual or transgender, anything encompassed in the whole LGBTQ plus classifications. Part of the ruling said that discrimination based on homosexuality or transgender status necessarily entails discrimination based on sex. The first cannot happen without the second. For example, If an employer fires an employee because she is a woman who is married to a woman, but would not do the same to a man married to a woman, the employer is taking an action because of the employee's sex, because the action would not have taken place but for the employee being a woman. So that was the reasoning, part of Neil Gorsuch's reasoning in that particular opinion there. So only since 2020 would it be nationwide recognized as a protected class for LGBT people. Some history prior to that 2020 decision. In 2014, the EEOC recognized LGBT protections. I'm using the shorthand LGBT. I recognize that there are additional letters and everything that comes after that, but I'm just using shorthand here to keep things short. So in 2014, the EEOC recognized the LGBT protections under Title VII sex discrimination. In 2017, the U.S. Justice Department, under the Attorney General Jeff Sessions, declared that Title VII does not protect employees from discrimination based on sexual orientation, which placed the Department of Justice at odds with the EEOC, and we had this conflict at the federal level. And it ultimately took the Supreme Court decision to resolve that conflict. Now, what we might see happen in the future, depending on who takes the presidency, depending on who takes Congress, which party, we could see us revisit this thing entirely. Somebody could bring a new case to the Supreme Court. They could rule differently. Congress could pass a law that would change things. So we'll just have to wait and see what happens. But this is the current state of things, is the 2020 Bostock decision. Okay. Talking about harassment. So it is unlawful to subject an employee to workplace harassment that creates a hostile work environment based on sexual orientation or gender identity. Some examples: using offensive or derogatory remarks about a person's sexual orientation or gender identity. Dead naming is another one of these vocabulary terms. It means the use of a transgender person's pre-transition name. So an example is a person who was born as a biological female named Mary, transitions to a man, renames themselves Roger, but coworkers and management refuse to change the name that they use, and they still call this person Mary instead of Roger. That's dead naming. Now, doing this accidentally, it can be confusing, especially once you get in the pattern of calling a person a specific name. So accidentally doing this probably isn't going to constitute harassment and probably isn't cause for people to get all up in arms. But when people do it repeatedly and intentionally, this is the kind of thing that will probably be considered harassment if it ever lands in court. So we have to be careful about that to avoid doing it ourselves. And if we're owners and managers of businesses, to step in and correct this harassment before it causes liability to the company. And also, we just want to be respectful of people and create a safe, healthy working environment. A worker is protected even if the harassers are wrong about their orientation or identity. This holds true for all the protected classes. You could have somebody harassing a man because they think he's gay, and it turns out they were wrong, and they say, well, this couldn't be harassment because they were wrong. He was straight the whole time. But it really doesn't matter. If you're harassing somebody because of sexual orientation, even if you're wrong, liability can still attach. So it's the kind of thing we have to step in and correct. A little bit of history here. In 1998, there was a Supreme Court case, On Call versus Sundowner, where the Supreme Court ruled that there can be a cause of action for sexual harassment, even if both parties are of the same gender. Okay, so that was the first time that was actually recognized. So a man can sexually harass another man, a woman can sexually harass another woman, and then we translate that into sexual orientation, gender identity. Now, at the time, so this is 1998, so now at the time, part of that decision was that it's harassment as long as it's clear that the basis for the harassment is not because the harassee is gay or lesbian, because at that time, homosexuality was not protected. It was not a protected class in the workplace. So things have changed since then. You know, the 2020 decision is going to be the current state of things. In 2001, there was a a separate case where male coworkers were repeatedly harassing another male because of that male being effeminate. He sued for gender discrimination. The court ruled that he actually has a cause of action because the harassment was based on a gender stereotype. Okay. I'll mention a lot of these historical cases just so you can see how the law has evolved over time and the way things have changed. Under transgender discrimination specifically, the ruling case right now, the prevailing case right now, is this 2020 case, RG&GR Harris Funeral Homes versus EEOC, which was then consolidated with the Bostock case. But we had a person, Amy Stevens, who was working as a funeral director, who was living and presenting as a male. So it was a biological female living and presenting as a male working at the funeral home. They notified the employer of their intent to transition from a male to a female, and then the employer terminated her. So then she sued for discrimination. The SCOTUS in that case says that Title VII language, because of sex, includes gay and transgender discrimination. So that's that case that I mentioned earlier, the Bostock case, the big one that is controlling right now. And again, we could see things change over time, but we'll see what happens. A little bit of history. Previous cases in 1993, there was Jane Doe versus Boeing, where Jane Doe was hired as a man and decided to undergo the change to a woman. They notified Boeing and asked to be allowed to dress as a woman as part of the pre-surgery requirements. Boeing allowed gender-neutral attire. This is Boeing's attempt to try to accommodate here. They allowed gender-neutral attire, but not feminine attire, and they weren't allowed to use the female bathroom. Okay, apologies for that. My dogs are going crazy because somebody was at the door. See if I can remember where I was. So Jane Doe versus Boeing. They said she could wear gender-neutral attire, but not feminine attire, and no use of the female bathroom. I think that's where we were. So Jane uses the female bathroom and dresses feminine in defiance of what Boeing had set out as their policy. She is disciplined. Her attire is being monitored by the company. She pushes the policy again and then is finally terminated. The court said Boeing had no duty to accommodate beyond what it had already done. And her claim of discrimination due to temporary disability was no good because it did not affect her actual job performance. So that was kind of a case of Boeing being a little bit ahead of its time in 1993 and trying to accommodate, but the employee was just kind of pushing things a little bit too far for what they were willing to accommodate. And so Jane Doe did not end up winning, although if that was to happen today, then things could easily be very different. In Ulaine versus Eastern Airlines, 1984, so even longer ago, a male is terminated upon becoming a female and alleges gender discrimination. The court finds that the discrimination was based on the change rather than the gender and affords no Title VII protection. And that was the attitude for a long time, is that discrimination against gay or transgender people wasn't necessarily sex discrimination because it was based on the change or the orientation rather than the sex specifically. And that just shows you how much things have changed in the last, 30 or 40 years. Under employment benefits, this was a controversy for a long time because if a person was gay and married, there was a lot of states where their spouse was not eligible for employment benefits like healthcare coverage and stuff like that. In the Obergefell versus Hodges case in 2015, Supreme Court declared that gay marriage was legal in the United States. So every state pretty much has to recognize it now. That's the kind of thing that could be revisited and could change again, depending on who's sitting on the Supreme Court, who is in Congress, who is in the presidency. But for right now, everybody has to recognize the employment benefits for homosexual couples, just like they do for heterosexual couples. So management considerations. So if I'm a business owner or manager and I'm trying to navigate this environment here, what do I need to consider? So one is don't discriminate based on sexual orientation or gender identity. Customer and client preference still isn't a good excuse, although it's the kind of thing that people try to use as an excuse a lot, saying, well, my customers don't want to see a gay man working in the front office or something like that. So that could lead somebody to either segregate or steer employees, saying, well, okay, you can work here, but we're going to keep you in the back. You're not going to have a client-facing job, or not. We're not going to put you in certain geographical districts because it's less tolerated there, that kind of thing. And that is the kind of thing that can potentially get you in trouble, especially when it would result in less opportunity for growth or income or whatever it might be. It becomes pretty clear that I'm less likely to get promoted or paid more if I'm in this specific area or geographic district or whatever. Then you're treating people differently, and that's going to result in discrimination and liability for the company. So I have to be very careful about that. Best to just avoid the practice altogether. Trying to prohibit a transgender employee from dressing consistent with their identity can constitute discrimination. So best not to go in and try to, monitor and tell people what they can and can't wear if we're treating them differently than anybody else of the same gender. I should, as an employer or manager, take claims of harassment seriously, investigate them. If there's corrective action that needs to be taken, go ahead and do that. This will, first, it will provide a safe working environment for my employees. Second, it's going to limit my potential liability for the company later. The last thing a lot of companies want to deal with is the time and cost that it takes to defend against discrimination or harassment lawsuit. So most businesses are trying to play it safe just to try to avoid that hassle. They want to focus on doing business rather than trying to fight these fights. There are a couple questions here. What about bathrooms? This is a point of contention. It will probably remain a point of contention for a long time. I just don't know which direction we're going to go as a country on these issues in the next 10, 20 years. Currently, people should be allowed to use the bathroom corresponding to their gender identity. A lot of businesses, and I've seen this out as I'm going around to restaurants and things like that, a lot of businesses are just adopting unisex bathrooms in an attempt to just avoid the controversy altogether, like single-use unisex bathrooms where we don't care what you are, just it's a one-seater, go in, do your business, wash your hands, and then we're not going to deal with the whole controversy over gender identity and all that stuff. So maybe we'll see more of that popping up. I don't know. We'll just have to wait and see what happens. What about, and this is a big question as well, what about when my religious beliefs conflict? So now we have two protected classes at odds with one another. Like if I have an employer who is a religious person and feels like they're being forced to tolerate homosexuality or just or transgenderism or just something that they feel conflicts with their religious beliefs. Well, it kind of depends. If you're a religious institution like a church or religious school, you have available to you the ministerial exception, saying that if something conflicts with your religious beliefs, then you have the ability to discriminate here where that would otherwise be prohibited in private employment. So not a huge issue there for churches, religious schools, and stuff like that. For everybody else, for government workers, private industry workers, there haven't been a whole lot of conclusive cases to definitely decide this. There was a Hobby Lobby case that dealt with birth control and this being a private for-profit institution, and the Supreme Court carved out a narrow exception for them, but it doesn't necessarily apply to every other business out there. So not entirely clear on that. Exactly. Probably best to play it safe and just hire the most qualified person, treat everybody fairly. This is the kind of thing that will keep you out of trouble most likely. If you really feel like you want to get in there and fight the power and fight the system and try to create change, then, go for it. But just be prepared to get mired down in lawsuits if you want to do that. In North Carolina specifically, we'll talk about some history in North Carolina. Now, North Carolina doesn't have any specific protections for homosexuality or for transgender people or anything like that. So we're mostly following those federal protections that I've already outlined. So most of this North Carolina section, I'm talking about some history here of how we've dealt with it in our state. So like I said, there's no state protections, but the SCOTUS decision in Bostock does provide that federal protection. One of the most infamous things that happened in North Carolina was this HB2 quote-unquote bathroom bill that was passed in 2016. It's where the General Assembly in Raleigh amended state law to preempt any local anti-discrimination or minimum wage ordinances. It removed the ability for people to sue in state court for employment discrimination. It stated that people had to use the bathroom that corresponded to the gender that was stated on their birth certificate. And this was in response to a non-discrimination ordinance passed by the city of Charlotte. And the people in Raleigh didn't necessarily like that municipalities and cities had the ability to go in and just create their own laws. So they just try to take that decision-making authority away from the cities and just say all the decisions are made at the state level and that's it. Your opinion on this will likely be highly influenced by your political beliefs. I'm not going to try to convince you to believe one way or the other. Those are decisions that you have to make personally. My approach in the class is not to indoctrinate you, but just to kind of give you the state of how the laws are working right now, and we dig into some history about the evolution of that law over time. Now, this HB2 was highly controversial at the time. It sparked a huge backlash, including the NCAA and the ACC pulling sporting events out of the state of North Carolina. It's caused a lot of loss of revenue. Mostly, this was repealed in 2017, but the repeal placed a moratorium on cities and counties passing new non-discrimination ordinances until January of 2021, after which we saw some municipalities like Asheville, Durham, Greensboro passing some new non-discrimination ordinances. In August of 2021, the Charlotte City Council approved a non-discrimination ordinance that applies to businesses of all size, which closed the gap because the federal law kicks in once a business has 15 employees or more. So the Charlotte City Council passes an ordinance that closes that gap and says even businesses with fewer than 15 employees are still protected. So this isn't a state level law. These are municipalities. So you really have to be aware of wherever you're doing business, wherever you're located. You just have to understand what the state of the laws are in that particular jurisdiction. Moving on a little bit, in 2024, it's very recent, U.S. Appeals Court said the North Carolina State Health Plan discriminated by banning gender-affirming care to transgender individuals. Prior to that, transgender care had been excluded from the North Carolina State Health Plan. This is for state workers, and I'm counted in this as well, a member of the State Health Plan. But prior to this, transgender care had been excluded since 2017. That was an appeals court. They could potentially try to appeal to the Supreme Court and see if the Supreme Court will overrule the appeals court. We'll, again, just have to wait and see what happens there. For public employees, rules can be different a lot of times just because the government is the employer. And since the government is your employers, there will be a lot of constitutional and state law protections that apply to government workers specifically. North Carolina courts have generally held that in order to justify discharge from a government job, the conduct has to have an actual effect on job performance as sort of a general guideline. And then there are just all sorts of exceptions here and there for various different cases. The two cases I gave you there happened back in the 80s. And this was a time where for police officers, you couldn't work and be a homosexual as a police officer. So Police departments were trying to deploy the use of polygraph tests to tease out if a person was actually homosexual, and if they were, then they could be fired from the police department. So that's what those cases deal with. That would be illegal now. That's just, I'm just sort of framing sort of how far we've come or how much things have changed since even the, not counting the 60s, even the 80s and 90s, the evolution of the law. Could a school fire a teacher after finding out they're gay? This depends on whether we're talking about a public school, in which case generally no, under the Bostock decision. What about religious schools? So private Christian schools or Muslim schools or, whatever you might be. If you're a religious owned institution, the ministerial exception probably applies there, allowing discrimination. And we have seen cases of people working for like Catholic schools, for instance, and it comes out that a teacher is gay or a teacher has a child out of wedlock or something like that. And since that conflicts with their religious beliefs, that person could be terminated and they would really have no recourse. But again, for public school employees, that would be illegal discrimination. I gave you a couple additional cases here at the end, just a sort of illustrative, again, of different ways that LGBTQ issues have been handled over time. So feel free to read more about those if you'd like to, just to delve more into the history. But for now, I think that wraps up where we're at for now. Again, things can change, and I'll try to update course content as things change and evolve. But to my understanding, this is the current state of the law. If you know something that I don't, or you think I made a mistake, please reach out to me. Again, I love to learn that I'm wrong and have the ability to correct myself. With that, have a great day.